Good evening and thank you for joining us. I'm Axel Gumbel. Robin Wolfram has the night off. Well, the trial of Shiloh Hendricks is now over, with the jury reaching a verdict late last night. Hendricks is the woman who was seen using a racial slur toward a child at a Rochester playground. After 9 hours of deliberations yesterday, the jury came back with a split verdict, finding Hendricks not guilty of disorderly conduct involving the child, but guilty of disorderly conduct toward the man who caught the incident on video last year. Hendricks received probation, a $1,000 fine, and 200 hours of community service. ABC 6's Caroline Weir joins us now live with reaction to the verdict and what's next as the defense prepares an appeal. And Caroline, you've also been looking into some of those claims made by Shiloh Hendricks' attorney after court wrapped up.
Yeah, Axel, that's right. Hendricks' attorney, Brian Corrales, made a number of allegations following the verdict, arguing the trial proceedings were not handled correctly or lawfully. He actually described it as the most unprofessional circus he'd ever been a part of.
This whole thing is f***ing bullshit.
That was defense attorney Brian Corrales' reaction moments after a jury found Shiloh Hendricks guilty on one count of disorderly conduct. After court, Corrales argued the trial was unfair and accused the judge of repeatedly interrupting him, limiting evidence, and mishandling the proceedings.
There are so many appellate issues. This was one of the craziest trials I've ever seen.
One issue Corrales repeatedly pointed to involved Rule 901 of the Minnesota Rules of Evidence, which deals with introducing evidence at trial.
Judge said Rule 901 of the Rules of Evidence only applies to prosecutors. You were there. I mean, come on. Come on. Look it up. You're not going to do the research. You're not going to look up Rule 901.
So we decided to look up Rule 901 and clarify whether it does apply to both sides with defense attorney Peter Martin, who has known Corrales for years and says he was in contact with him throughout portions of the trial.
So Rule 9 requires the prosecution to turn over stuff. And if they didn't turn it over, that's a clear violation of Ms. Hendricks' rights in this case.
Another claim Corrales made was that the Rochester community no longer cares about the case. So we asked people in Rochester whether they agreed.
I think most of the people in the community have followed it, maybe from one extreme to the other.
Now the focus shifts to what's next. Corrales says he plans to appeal the conviction, arguing multiple issues throughout the trial made for an unfair proceeding.
When you appeal, you also order transcripts. And so the Court of Appeals will be able to look at a verbatim transcript of actually how things went down. And
while Martin says Corrales' conduct in and outside the courtroom could lead to scrutiny by the Minnesota Lawyers Board if a complaint is filed, it would not impact his ability to appeal the conviction. It is unclear at this time when Corrales plans to file that appeal, but Martin says that process we could likely see go on for over a year.
To all units, proceed to your post assignments. All units, proceed to your post assignments.
That's the sound of the police. Whoop, whoop. That's the sound of the beast.
You guys know we're always encouraging people to do their own research, especially when it comes to finding ways to help protect their retirement savings. If you've been curious about physical gold and silver, Goldco has a free gold and silver kit that explains how precious metals may help diversify your retirement portfolio. Whether you're just starting to look into it or you've been thinking about it for a while, it's a simple way to get more information before making any decisions. Right now, they're also running a limited time promotion. Qualifying customers may be eligible for up to a 10% instant match in bonus silver and a free solar generator. So go to probablecause.gold to see if you qualify. There's no cost, no obligation, and you can decide for yourself whether it's something that makes sense for you. And those of you who are of a certain age, this is really great for IRA rollovers. So go to probablecause.gold and check it out. Yeah, baby, it's episode 41 of Probable Cause on July 28th, 2026. Jeff Norman and Greg Dillon with you, as we always are. And tonight our special guest is Aaron Terr, who is the Director of Public Policy at the Foundation for Individual Rights and Expression, known as fire. And I have to talk to you about the name and the acronym. Don't let me forget that, Aaron, but let's not start with that. How are you tonight, Aaron and Greg? You guys doing okay?
Very good.
Doing well, yeah. Good to be here.
That's good. One of you, I need to give me a nice long answer so I can get our names displaying because they aren't working as we normally have them, but I will fix that. In the opening, we saw a news report. I don't know how many different news reports you guys might have seen, but I've seen a bunch of them, and I think it was kind of typical of them. And one of the things that worries me about this is that they didn't even mention it's a First Amendment case. They mentioned, the disorderly conduct, and they mentioned that there's all these appellate issues, but the average person watching it hears that, and they probably think, oh, disorderly conduct, something probably happened in the way of unlawful behavior. And it's just, are you worried, Aaron, that, for example, they might win on appeal based on some of these irregularities, and they won't even rule on the First Amendment issue? Is that a possibility?
It is a possibility. Sometimes courts do try to rule on cases without reaching constitutional questions, especially if they think that it might be difficult constitutional issues to grapple with. But I do expect the attorney to raise the First Amendment issues on appeal, because you're right about that report that we just watched, but I've elsewhere seen him talk about the First Amendment issues at stake here, and I have seen other reporting on that. So I think it is something. Good. I think the case has been framed as a free speech issue in many quarters, which is good to see, because it absolutely is. And what I would love to see is, my ideal outcome would be for this case to go all the way up to the Supreme Court, and the court declare that the fighting words doctrine is no longer a thing, that it is dead, and it's incompatible with First Amendment principles, and we're no longer going to apply it. That would be my ideal outcome.
Music to my ears. I would love that too. I mean, I think one of the things I wanted to ask you is, because you have perspective on all this, you sit there at FIRE and all these different cases come to you for consideration. And so you really have perspective on how ridiculous this ruling is and how important the issue is compared to others. So a little reality check. To me, it seems like one of the most ridiculous and one of the most important First Amendment cases that's out there. Is that fair, or am I just reacting emotionally?
Yeah, I think that's fair. I mean, it's what this case comes down to is that somebody was convicted of a criminal offense for using a taboo word, right? I think it's very difficult to imagine that this prosecution would have been brought if, holding all else equal, right, she just didn't use that one word during their argument. I think most people would look at it and say, why is this person being prosecuted? I mean, it's two people having an argument in a public park. It's something that happens probably dozens of times every day in this country. And it's not a criminal matter, as long as nobody's making threats, as long as nobody's becoming violent. It's just people exchanging words. It's not something you should be prosecuted over. And I think the only reason this prosecution was brought was because the video of the incident went viral. Obviously, the speech that she used is deeply offensive to many people. And there was a lot of pressure from local activists and I think some politicians to bring this prosecution. So I think that's ultimately
Minnesota.
And it's in Minnesota, right? So
and the Somali population is involved. The photographer, the guy who took the video, which I'm about to show, is a Somali, and the child and her father, I don't know about the mother, I guess are Somalis too. But I mean, I have no opinion on that nationality, but I'm just saying in Minnesota, that is a hotbed issue.
Aaron,
yeah, I think that
brought up a point I want to touch on, because before we get too far away from it, when you said that, the taboo word, it always arouses my interest that we reserve a special status for one word and one word only. There's no other word in the English language that has the same reverence and the is considered so verboten than that one word, which is regularly used amongst a certain group of people, and no one seems to be ever offended by it. And so, you know what I'm talking about. Contacts, movies, songs, interviews. Black people use the word regularly, and I'm sure it offends a small group of people, but certainly not a large group of people. And they're given a pass on using the same word that someone now can be arrested for using during a heated argument.
Your girlfriend Helen's loving you as usual. As always, Greg pinpoints the issue. And, hey, Aaron, before you reply to that, I think there's a little audio issue, Greg. Can you tap on your microphone? Because I'm not sure.
Oh, I'm sorry. Hang on. How are we doing now? Any better?
Yeah, a lot better.
I should have it here.
Yeah. When you utter such brilliant words, you're kind of squandering your brilliance if we can't even hear you. Aaron, do you want to comment on the special status of the F word? And here we are having
N-word.
Oh, yeah, I meant to say that. Sorry. And here we are, even the F word you can actually say, fuck. And here we are having to say N-word, which I feel absolutely ridiculous saying it, but I'll get in trouble if I say it. We're on YouTube, for example. So
you may get banned.
Yeah. So I won't say it. I'll say N-word, throughout this broadcast. What's your take on the special status of the N-word?
Yeah, it's probably I think it's true that it's one of those few words that it's
only word, Aaron. I don't want to argue, but it's the only word. You can say Nazi, Gestapo, SS.
Well, I can think of other
gender slurs.
I can think of other
slur you can create. There's never comes even in second place to that word.
Yeah, I mean, I think there are other words like I think queer would be one where like the community itself has sort of reclaimed it for itself, but if other people use it, it's considered a slur. I'm not saying it's on.
Never get arrested
the same reaction for sure.
No, you won't have your career. You won't have your career. Well, I guess you could theoretically if it's a gay rights protest or something. Yeah. Well, I thought you were going to say the C word because I saw on your X page the LA City Council wants to ban the N word and the C word. This is funny.
Jeff, when we say the C word, are we talking cracker?
And we're talking cunt.
I know. I'm trying to make the analogy that
I know.
Like
I just wanted to say it.
Word, but when it's used as a cracker, it's not offensive. But if you use the N word, which sounds very close to it, it is.
All right, don't be cunty, because the LA City Council has already thought about different variations of it. Look at how they worded this prohibition. To avoid ambiguity, the N word is spelled N followed by I followed by so on. And then they say the C word is C followed by U. And then that's just to make sure examples of variations that are also prohibited are the plural form. And if you add ish, Y, like cunty, like I just did, this is really funny. So cunt is a second place, but I think the N word is number one.
Yeah. And look, it's people can have different opinions about that word and who can say it and whatever. Like, as long as you're just arguing, people are arguing with each other about when it's acceptable to use that word, that's fine, right? I mean, that's all free speech. People can say, I think only this demographic should be able to use it, not that. The problem here, though, right, with Shiloh Hendricks' case is that the government is trying to dictate who can say the word and who cannot. Now, that's the real First Amendment problem, right? So, there's just no word in the English language that the government can just decide is banned. There's no word, there's no viewpoint, there's no idea, no matter how offensive some people find it, that the government can say, you are not allowed to express this word, idea, or viewpoint. There's just nothing that they can never do that, right? That's the number one thing that the government can't do under the First Amendment is just stamp out a particular idea or word. Because really, once the government starts banning particular words, that is just the beginning of the road towards banning ideas, right? I mean, so like why, once the government can say, we can ban the N-word because it's too offensive, what's to stop it from say, we're also going to ban you from, I don't know, arguing against affirmative action because that's offensive, that's too offensive.
or anything. If there's,
right?
you can make an endless list of offenses.
Right.
Yeah.
Or for or for a Republicans to say that we're going to ban you from being able to say like all cops are bastards or whatever slogan on the left.
Yeah,
that
being
like.
punished because certain people are offended. That's why it's such an important issue. And I think actually, and I hope I say this in the right way, because I know the people who don't really appreciate the importance of this issue will say, well, why do you need to say the actual N-word? And well, it's not that I need to say it or that I like saying it. Mm-hmm. It's that the mindset contributes to people being punished by the state for it. Part of the reason this was prosecuted in Minnesota is because we already have this situation where you can't even say the N-word. And now they're taking the next step. Now, I don't know if Fire wants to take this stance, and it's not exactly a legal issue, but I think we should maybe counter that it's taboo to say it. I mean, even when it's not, you're not being prosecuted for it, is what I mean. You know what I'm saying?
So actually, we have taken other cases where it's not a case of criminal punishment, but for example, we've had numerous cases over the years where a college professor will say the word in the course of teaching about a text or a court case or something that itself uses the word. So in other words, like he'll be quoting the word, or the class that they will be about the subject of taboo language or the way that we use language socially. And so he makes the professor will make a pedagogical decision that I'm going to say the word because I think it's important not to censor it in this context. And a student complains and the administration punishes him.
Yeah, just the utterance, like the sound of the word.
And so
let's look at the last sentence here in the LA City Council ban. They make a point of saying that, this is not allowed to say it even when you're not expressing a non-offensive or non-vulgar viewpoint.
Right. And
meaning you can't even quote somebody or anything like you just said.
Exactly. That's what's so crazy about the city council rule and why Fire is suing or representing an LA resident who's suing the city council. And that's exactly right. We do make the argument that context matters, right? Yeah. If a professor was standing in class and calling a black student that word, that would be a different matter, right? Like that might actually be something that would be something that they.
What a controversial position.
Here's my question. But if another black student gets up and calls another black student that word, it gets a pass. There's no
usually, yeah.
Usually, show me a case where it's been where I'm
wrong. I've heard black people just object to other black people using it, but it doesn't usually lead to punishment, career ruination, or anything like that. But I have heard black people say that they wish other black people wouldn't use the word.
Oh yeah, no. There's certainly a percentage that do, but the majority of them seem to have no qualms about it because they applaud it in comedy acts of black comedians.
All right, we should show the video that we're talking about, Shiloh Hendricks. But before I do, I just want to show you a tweet that I got on my X page today that I responded to. The guy says to me, I guess he's a regular viewer, by the way he worded it. He says, "You're a fucking disappointment, Jeff. She got found guilty of disorderly conduct." And I had a similar exchange on Facebook with a couple of other people. And this is what I mean, that these news reports aren't even mentioning that it's a First Amendment issue. And it's such a frustrating, circular argument to say, well, I'm wrong because she was convicted of disorderly conduct. Well, nobody's quibbling over officially what she was convicted of. The argument is that she shouldn't have been prosecuted for disorderly conduct.
Right, exactly.
How do you have a discussion with people who communicate like this? It's so frustrating.
Yeah, the courts cannot construe criminal statutes or any other statute in a way that would violate the First Amendment. The Constitution takes precedence over any criminal statute. So if the statute is worded or applied in a way that would reach protected speech, it's unconstitutional. But
I was just about to play the video. I was just about to play the video, but since you mentioned the statute, here it is. So it's Section 3, I believe. Correct me if I'm wrong, Aaron. This is what Ms. Hendricks was convicted of. And the statute, to me, is unconstitutional on the face because it's so vague. It's illegal to engage in offensive, obscene, abusive, boisterous, or noisy conduct, or in an offensive, obscene, or abusive language tending reasonably to arouse alarm, anger, or resentment in others. Almost every one of these words is ridiculously vague. Am I right?
I personally agree with you, but what actually, so this actually isn't that uncommon language to see in disorderly conduct statute. If you look at the statute in like any city in America, it's I would say it's even likely to have language like this. Some of them are drawn more narrowly.
Some of them are better, like they'll say you can't communicate above a certain decibel level at certain hours, don't use amplified music, something like that.
Where they make clear that there has to be something beyond like mere speech that, to convict. Right. But the way courts will often, when they're asked to, or when they're adjudicating constitutional challenges to these statutes, what they will often do is kind of just put a limiting construction on it. So they'll say, yeah, we see that the language says like language that will cause alarm or anger in others, but we're going to interpret that to basically be equivalent to the established fighting words exception to the First Amendment. So I don't know if that's actually happened with respect to this particular statute, and maybe that's Well,
are you familiar with Andrew Branca?
I'm not.
Oh, he has a very popular podcast called the Branca Show, I believe. Amazing, the Branca Show, and his name's Branca. He's been our guest a couple of times. He did a commentary on this, and he said that the Minnesota Supreme Court has interpreted, and they did put conditions like that, just like you said. Right. So it's very complicated, I guess, for the average person to have to be familiar with not only the statute, but the court ruling.
Right.
Yeah.
Right. That's why I say I personally agree with you, because I think that these statutes should be struck down as unconstitutionally vague and or violations of the First Amendment. But that's just not, I think what it is that judges think they think that it's difficult to write a disorderly conduct statute in a way that's going to capture all the types of actual punishable conduct that the state wants to get at without having this kind of very broad language. So they're reluctant to just strike it down entirely.
Right. Full disclosure, I was once cited for violating such an ordinance in Boise, Idaho, many years ago. I did a hidden camera prank for Fox. And the way it read, I don't remember the whole thing word for word, but the gist of it was that loud or unusual noise was prohibited. And this is actually sort of what got me on my high horse as like a fake internet lawyer, because I immediately said, what? How can that be constitutional? I mean, speaking Spanish in Boise is probably unusual, so I see what you mean. It's they have this elsewhere too, huh? It's common. Jesus, that's all right. Let's play the video. This is Shiloh Hendricks. This is a mom, Shiloh Hendricks, a mom in Minnesota who was in a playground, and she was with her small toddler, and according to her, a 9-year-old boy attempted to steal something from her backpack, and she got very angry. The boy was Somali, a black skin. She ran after him. This we do not see on video, but apparently she ran after him and got the thing back. She was angry, and she called him the N-word. And then what we do see in this video is a Somali cameraman, who, by the way, this guy in the past has been convicted himself of disorderly conduct and was also charged with sexually assaulting a teenager. And here he is hanging out in a children's playground with a video camera. You can draw your own conclusions from that. Anyway, so he confronts this woman, and what you see in this video, the way she reacted, is what the jury convicted her of, is what they deemed to be disorderly conduct. There's a lot of controversial allegations that make it into the news, but seldom does the public get to see everything that happened and able to form our own opinion. But this is the position we're in now. This is it. We see it.
Him a nigger, the child?
The fuck you talking
Did you
about?
call the child the nigger word?
None of your fucking business.
It is my own business. You call him a nigger? Okay, why don't you have the balls to say it right now again?
Fuck you, nigger.
Okay.
Nigger.
All right, that's what you say.
You don't go digging through people's shit, you dumb fuck.
Nobody dig into your shit.
A little fucking kid just did, you dumbass.
That little kid, you call him a nigger?
Yeah.
The little child?
What if he acts like one, he's gonna
Are you about to hit him? You chase him here?
He took my son's stuff.
So that gives you the right to call the child, 5-year-old, a nigger, the N-word.
If that's what he's gonna act
That's
like.
what you're gonna call him.
That's what he's gonna act like.
You know, that's a hate speech. And you can be recorded for that.
I don't give a shit.
Huh.
Fuck off.
Okay, we'll see about that, what the internet has to say about you.
We'll see what the internet has to say about you. Well, he was right about that. I don't know if he was right about anything else. So he went after her because he didn't like what he had witnessed. He dared her to use the N-word. So I timed it over the span of a whole 3 seconds. After he dared her to say it, she said it 4 times. And that's the disorderly conduct, a crime in Minnesota.
Yeah, and to go back to the fighting words exception, the reason I don't think, even assuming that the fighting words doctrine is still applicable, still a recognized exception to the First Amendment, I don't think it would apply here, because the way fighting words are defined are face-to-face communications that, under the circumstances, are likely to provoke an immediate violent response from the person that you're delivering the words to face-to-face. But when you look at this video, it's a woman carrying her child, walking away from a person who's asking her to say the words in question. She turns around, she says it, she continues walking away. I don't think there's anything about these circumstances that suggests that he was going to immediately respond by punching her in the face.
Aaron, I think I read that it's been more than 80 years since the fighting word doctrine has been successfully applied in a criminal prosecution.
So it's been 80 years since the Supreme Court has upheld a fighting words conviction. There have been lower courts that have upheld convictions based on fighting words.
Okay, thank you.
But usually you need something more than it can't just be based on the word that was used. You need something more that indicates like
above and beyond
some level of kind of aggression, that there was like an imminent violence was going to break out between these two people. And I don't think you have that here. And I think the fact that at the end that he's filming her and trying to get her to say it, and the end, and he says, we'll see what the internet says about you, shows that he wasn't looking for a fight. He was just trying to get her to say it on camera so that he could post it online.
Yeah, I mean, I get the impression he was goading and challenging her.
He sure was.
Daring her.
And I don't think he committed a crime, but I think he came closer to committing a crime than she did. Right? He provoked the confrontation,
Yeah, I mean, I don't think there's any crime here, but but it's
right. Somerville John in South Carolina asks if she gave him permission to record her. Let me try to be a fake lawyer and see what the real lawyer says.
Doesn't need it.
No permission needed because it's in a public space, only if it's where you're entitled to privacy, like in the bathroom or something. Am I right, counselor?
Yeah. That's right. Yeah, you have a right to record. You generally have a right to record in public, and you have the right to record police. That's something that comes up a lot.
I think you made that point in your, I don't know if you call it a statement or a bit of an article or an essay that you wrote about this. I think you were making that point about the fighting words.
Mm-hmm.
Yeah. Right.
Yeah.
Right. So I don't think it's a big deal, but there's a little bit of a Twitter feud going on. This guy, Tom Hennessy, who's an independent journalist in Minnesota, who has been covering the case, and a lot of people have been giving him credit for doing a great job. He's been really on the case the whole time. He was in court all 3 or 4 days. But he was complaining about fire not getting involved earlier. I don't think it's fair at all. But let me just explain what I'm showing on the screen here, because what Mark Randazzo said, he's a First Amendment attorney, and he came to the defense of fire. That part is missing. But this guy, Tom Hennessy, is criticizing your organization for it. And then Mark Randazzo defends fire, saying, they have to turn down a lot of cases, and they also tend not to get involved until the appellate level. You're being a baby, you shouldn't complain. So then he says, in response to that, Tom Hennessy says, since you're not in their organization, your speculation is irrelevant. Let's hear it from Aaron Terr. If only we had Aaron Terr on the show and we could ask him.
Yeah, I'm happy to talk about this. So there's a couple of things. That I want to say in response to this. First is that FIRE, our organization, we're not criminal defense lawyers. We've never done criminal defense. We've never taken a case to criminal trial or represented a client in a criminal matter because that's not within our expertise. So I would ask Tom Hennessy to try and find one example of us doing that if he thinks that the actual reason we didn't take this case is just because we thought that it was too toxic or whatever. Secondly, we also did we did receive a case submission from someone. I don't know if it was him or I think it was someone just claiming to be Shiloh Hendricks's manager, which I don't think we. Yeah,
I'm glad you mentioned that because he used the word "we." He said, we submitted all relevant details. Well, I thought he's a journalist. Who is he to be?
I'd never heard of him before he started calling us out. Someone did reach out that claimed to be acting on behalf of Shiloh Hendricks, though we didn't have confirmation of that, and it wasn't her actual lawyer. But we did, as we often do in these cases, we will say, is the person, or if the person themselves, if Shiloh had submitted the case to us, we'd say, do you have a lawyer? If not, we'd be happy to try and locate you one, because we have a broad network of attorneys outside our organization who do criminal defense work and do have expertise in the First Amendment. And we hook people up with lawyers all the time, even if we can't take the case ourselves. But she already had a lawyer. She already had a lawyer at the time a
very passionate one.
A very passionate lawyer. So
his name is Brian. Brian Corrales, I believe, isn't it? Yeah,
that's right.
Karalus.
Right.
I think it's
So
we saw him in the opening say that what happened was fucking bullshit.
That's right.
This whole thing is fucking bullshit.
He's a passionate advocate for his client. What can you say?
Now, in that news report, I don't know if they know what they're talking about, but they alluded to the possibility. This was, by the way, a 13-minute rant that he did outside the courthouse after the verdict. And as Helen said before, Helen's one of our regulars who's very smart. And I saw her point out that they were forced to deliberate for 9 hours. Instead of sending the jury home when it got into the evening hours, she made them stay until 10 p.m. and they finally reached a split decision. We should also explain the split decision part. You want to do that?
It's a compromise verdict, right, Aaron?
Yeah.
Oh yeah. So there were 2 counts of disorderly conduct that made it to trial.
3. Well, three.
There were 3 that were charged, and then only 2 made it to trial. One based on Shiloh Hendricks's interaction with the child and her allegedly chasing him and yelling the slur at him, and then one based on her interaction with the bystander who was filming her, that video that we just watched. So she was acquitted of the charge as to the child, which is important because I have seen a lot of misleading commentary on the case that implies or suggests that the conviction was based on her chasing this child around the park. And by the way, that was my initial somewhat hesitancy about making a full-blown statement about the case when it was initially announced, because there were allegations that she was chasing a child around the park, and that could, I could see that potentially being disorderly conduct, but ultimately the jury found her not guilty of that charge.
Yeah, and we didn't see that. There's no video of that.
And I'm guessing that's why, because there wasn't.
I don't blame you for hesitating a little bit, but come on. I mean, she believed, I assume it happened, but we know for a fact she believed that the kid stole her property. So you're entitled to get angry and run after and get your property back,
No, I think that's right. But it was just difficult to draw a conclusion without having video evidence of what exactly happened there, right? But from the beginning, I think there was no doubt that her interaction with this bystander was absolutely not disorderly conduct, because that was all on film and we could just see it for ourselves.
But Jeff, I think the irony of the whole thing is, number one, it wasn't a 5-year-old child. He was 8 or 9, depending on what article you read. Yeah. So it was less offensive to call the minor the slur, but it was worse when she called the adult the word that he was asking her to use. So I find that completely confusing, number one.
They're trying to make
And if you don't find the first charge valid of her calling the minor the word, then the second challenge by the the cameraman falls apart. I mean, now it's his word against hers, and he's goading her into using the word again, and she rises to the challenge. I can't comprehend how a jury would
And by the way, the cameraman disappeared. He didn't testify at the trial.
Correct.
So he's the quote unquote victim of this disorderly conduct, but he wasn't even there. And he's such a victim that he's getting hundreds of thousands of dollars. Let's look at, in fact, there's a lot of people making money off this. The NAACP started a fundraiser for this guy and the family. By the way, the kid is also autistic, so they're trying to make him into a sympathetic figure.
He's also 9 years old.
Well, Shiloh didn't know that he's autistic. All she knows is a kid stole property from her. And he wears an ankle bracelet because he can't control himself in public. So, I mean, I don't want to be too unsympathetic as far as what the father has to deal with. But, I mean, in terms of what Shiloh has to deal with, this kid whose behavior is uncontrollable because he's so bad that he has to wear an ankle bracelet, was up to whatever shenanigans he tends to do regularly. So here's one fundraiser. The NAACP raised over $300,000, and the family has their own separate fundraiser. Now they're only getting $8,600. What's happening there? I guess all the sympathetic people gave their money to the other fundraiser, and now the cameraman who disappeared. But presumably he can still access funds. He's got $40,000. I have to tell you, as upset as I am, and Brian Karalikis, we should start fundraisers because we need to go to therapy. We're so upset about this First Amendment violation.
Jeff, my understanding from reading the articles was Shiloh's fundraiser was almost to $900,000.
Oh yeah. Because, well, here, let me see. I think I got some more clips of Brian Karalikis, the attorney. Let's see. I don't know which one it's in. Let's take a look at one of the video clips.
It's open. He testified under oath and perjured himself. He perjured himself over and over and over and over again. This was without any stretch of the imagination. It was like I was fighting the prosecutor and the judge. It was like I'm taking on two parties at the same time. The judge and the prosecutor. It was very bizarre. Very bizarre. GoFundMe. Huge, worldwide, giant. It's like Google, right? This is so big. My investigator was going to testify that this page with Shire Jamali's name on it. 5-year-old. The kid's 9, 5-year-old, $340,000 he raised. The judge would not let me show it to a jury.
All right, so Shire Jamali is the father's name. He's the father of the kid. And I think what he's saying about perjury, Aaron, is that the guy claimed there was no GoFundMe that he was making money off of, but then they found that there is. Is that what he means by perjury?
I'm not entirely sure. I mean, that sounds right to me, but I'm not totally keyed in on that particular issue or what happened at trial there.
And also, he didn't. Now tell me how rare this is in the world of jurisprudence. He didn't find out who this father was, that what his name was, and that he was going to testify until the first day of the trial. That doesn't, as a layman, that doesn't seem right at all.
No, I think usually, and I should preface this with saying I'm also, again, not a criminal lawyer, but I did take criminal law in law school.
And just make it up.
But yeah, no, you generally, the defense is generally entitled to have notice of all the evidence that's going to be used against them at trial, which would include any witnesses that are going to be testifying on the prosecution's behalf.
Isn't it Brady material that's eligible through discovery?
Brady material refers to evidence that's potentially exculpatory. Yeah.
Well, okay, so not necessarily Brady, but when you file a motion for discovery, the prosecution has a legal obligation to turn over all of the evidence they intend to present.
Correct.
To give you sufficient time to prepare, not on the day of.
Yeah, I exactly. There has to be adequate notice of the evidence that's going to be used against you. You generally can't just spring a witness on someone at the last minute.
Right.
At least unless
Well, that's what happened.
Yeah.
So and then he said the judge wouldn't let him introduce this evidence in the trial. And his argument, you tell me if this is standard or not, it sounds standard, is that the jury's entitled to know if somebody's benefiting financially, because then they can factor that in as to what the motivation is, as opposed to just telling the truth, right?
Sure, you generally can question witnesses to try and impeach their credibility, and that might go to their credibility. So
this is just mind-blowing. Like I said before, I wish it was all focused on the First Amendment issue, but this is so outrageous, we also have to expose it. Here's another clip.
We have so many appellate issues, I don't even know where to begin. Judges screaming at me during the trial. Judges interrupting me every time I want to make a record. Judge says to me, Mr. Corrales, you keep wanting to make a record after I ruled. This is crazy. Most rulings during a trial by a judge are made during the trial. And then when you take a break, you make a record, right? You take a break, you make a record. I kept asking. If you're in there and you watch the trial, I kept asking. I need to make a record. I need to make a record. She'd get upset, run in the back. Get upset, run in the back. Your Honor, I need to make a record. It started piling up. All these objections started piling up. Your Honor, I need to make a record. I need to make a record. She'd run in the back. I'm like, Judge, we got to make a record. This is insane. This isn't law. This is a circus. This is monkey court. This is nuts.
Monkey court. It's a good thing the judge wasn't an African American. She's a white woman.
Jeff,
her name is Judge Krista Daly. That's the judge.
He sort of misrepresented, though. He said anytime you have a trial by a judge, but it was a jury trial.
Yeah, but he's talking about how the judge was conducting the trial.
Well, then he misframed it, because he clearly said this was a trial by a judge, and it's like all trials are by a judge.
All right, so he misspoke. All right, so he misspoke a little bit.
I kind of interpret that as him saying the judge was like taking over the trial and kind of.
I understand.
Oh, okay.
But I'm saying if you were watching the interview, you would be led to believe that it was a judge trial and not a jury trial.
Yeah, bench trial.
Yeah.
All right. So I apologize, Aaron, if I'm asking you questions that are outside of your area of expertise.
That's all good.
But are you familiar with what he's talking about, this making a record business? It sounds to me like, as a layman, what he's saying is when an objection is made and then the judge rules it, every single time it happens, they don't stop to put it in the record because it slows things down. So later on, they ask for it. And I think that's what he's saying, is that's just a routine thing. But she wouldn't allow a lot of the things that were said to be put in the record. That's what he's saying.
I guess I'm wondering. Yeah, I mean, I'm getting outside of my expertise here, but I would think. I mean, a lot of trials, right, have a stenographer who's taking notes the whole time. I don't know if maybe certain like trials like this that are very relatively small potatoes don't necessarily have that, and maybe the judge exercises their discretion about when to put things on the record. I know for like major criminal trials, you would generally have a stenographer who's taking down everything, and that eventually will be made part of the trial record. So,
but he's doing that to set up his appeals claims afterwards.
Yeah.
Is the reason why he's doing
it. You want anything that's you want a record, of course, of anything that's going to be related to an issue that you might raise on appeal.
See, this is an argument for there being cameras in the courtroom, because when a judge misbehaves, it's difficult to hold them accountable if nobody even sees it. Do you guys have any opinion on having cameras in courtrooms?
I'm in favor, perhaps unsurprisingly, as a free speech lawyer, because I tend to just think more openness, more transparency is a good thing.
Right. A transcript is never going to accurately reflect the judge's demeanor during the course of a trial. When a stenographer reads back testimony, it's usually flat, sort of emotionless. If you're watching videotape, then the person can evaluate for themselves. how upset, how angry, how passionate remarks are being delivered, especially from a judge who should be neutral and objective.
Yeah, or how rude or disrespectful they were.
Right,
if
because the
that's
jury
case.
picks up
like
on
remember
all
that judge in the Tina Peters case in Colorado? We saw how disrespectful he it's just unnecessary. It's good that the public saw that.
Yeah, Jeff, in that interview with Shiloh's attorney, though, I found it interesting. He was haranguing the press about how unfairly they were covering everything, and when the woman journalist filed her report, she says, his take was that a lot of people really didn't have any interest in this, that it wasn't all that big a deal. And so she says, well, we went out and interviewed several people about this, and this is what they had to say. They showed one interview of a woman who said, yeah, there's a lot of interest in this. And I'm thinking,
yeah, I know.
You're just reinforcing the point he's making. You found the person that agreed with your position, and you aired that.
I know, and she was so vague and milquetoast what she said too. It wasn't even a good sassy quote. So yeah,
correct. So
totally.
His point was well made, because that's exactly what they turned around and did.
Well, there was obviously a lot of interest in this case. The media was requesting that it be televised, and the defense said, yes, we want it televised, but the prosecution did not want it televised.
And why did the prosecution get to win out on that argument?
I don't know. Do you know how they, I guess the judge, I don't know what the criteria are for making the decision. Do you know, Aaron?
I don't know. I mean, it would be a state-by-state thing, and I'm not sure what Minnesota's rules are, what their court's rules are.
Right.
I'm guessing, though, that it must happen at some point, or else he would never even try to make the argument. If it's prohibited, I don't see how you can make a good faith argument that it should be televised.
Right. That would suggest that at least sometimes it's allowed.
The only argument I've ever heard as to like why it shouldn't be well, I mean, aside from, in certain cases, this would be the exception where somebody's going to testify who's in danger, like you're in the witness protection program or something along those lines. But I think that should be the exception rather than the rule. The only other argument I've ever heard is that, well, people act up for the camera, to which I say, so what? Let them act up. Have you guys ever heard any other reason presented, like why it shouldn't be televised?
No, that's the main one I've heard too. Is people are going to perform for the camera, or it's going to be kind of like turn into a spectacle. But I don't think that argument has really borne out in the jurisdictions where they do allow.
Yeah, right. Now that it's happened over and over and over.
So
again.
I feel like it's kind of disproven that argument.
Good point. Good point. All right, let's talk about some of the other cases that has caught your attention. You talked a little bit about how fire operates. You want to say a little bit more about that before we get into some of these other issues? How cases are picked and, the history of fire or anything like that?
Sure, yeah. And I'll also just mention, by the way, that we have already reached out to Mr. Carolus. I'm not sure if I'm saying his name correctly, but the attorney to offer our support in the appeal. And that is generally when we would weigh in as like amicus or a friend of the court, if we were to file an amicus brief. It's usually, often you only can do it at the appellate level when, the factual record has already been developed in the trial court, and now the constitutional issues are squarely presented on appeal. So we have a pretty robust amicus practice, and we would definitely consider filing one in this case. Okay. But as far as the cases that we take, I mean, the other thing is that, people should understand is that we get a tremendous number of case submissions every day. Every week we're getting like dozens of submissions. So we can't even take every case that we think has merit in terms of a First Amendment argument. But we try to take the cases that we think are important, that we think have the potential to be precedent setting, or where we think the First Amendment violation is especially egregious and shouldn't be allowed to stand. And we also do try to have a good ideological balance in our caseload, because we're a nonpartisan organization. We take that aspect of our identity very seriously, but we defend speakers on the left and the right and everywhere in between. We don't care who's being censored or who's doing the censoring. The only thing we care about is this speech that's protected under the First Amendment. So we try to have a bit of a balanced caseload, and we also try to dip our toe in different subject areas, right? So we might have a case that involves like regulation, emerging technologies like regulation of social media or artificial intelligence. We will have a case that involves, we've always been an organization that's been focused on higher education for a couple of decades. That was actually our exclusive focus, was censorship at colleges and universities. So we have cases in that area. We have cases involving K-12 censorship. We have cases involving people who've been censored at the public comment period of their city council or school board meeting, and a whole range of other topics.
And you have, my impression anyway, is you've got progressives and conservatives, people from various political spectrums, and the organization as a whole, it seems to me, is very sincere about just the issue of free speech, regardless of politics or what the controversy is. Am I right about that?
Yeah, one of the things I love about FIRE is that we have a very politically and ideologically diverse staff, but we all agree on one thing, which is that free speech is important, and everyone, it's a fundamental freedom in this country that everyone is entitled to, regardless of where you fall on the political spectrum.
In other words, you operate as the ACLU used to, but doesn't anymore. I know you work with them sometimes, and you're a nice, polite man. You don't want to say it, but I'll say it. They turned into an anti-Trump woke organization, and you guys are the real deal now. But the problem that I alluded to earlier is your name, FIRE. Now, it's a great name in terms of the connotation. Nothing wrong with the connotation. But if you do a Google search for FIRE, you're in competition with millions of other uses of the word. It doesn't even show up. Whereas if somebody searches for the ACLU, it'll come up, the one and only ACLU. You don't have to remember that it's the American Civil Liberties Union. But with FIRE, you have to remember that it's the Foundation for Individual Rights and Expression. Who the hell can remember that? Has this come up in your meetings? It's a very difficult name. I don't know if it's actually a problem for you, but I would imagine it is.
I will admit that there have been times where I've been frustrated trying to Google something about us, and I will actually have to start typing in the full name in order to get the relevant results at the top. But I guess the problem is that our organization was founded in 1999, and the founders probably didn't have search engine optimization at top of mind at that time. So that's the name they went with. And when we expanded off campus in 2022, we used to be the Foundation for Individual Rights in Education when we were solely a campus outfit. And when we expanded, we wanted to keep the acronym because we had built so much goodwill around the name already. So we changed it to Foundation for Individual Rights and Expression. But I think keeping the name recognition at this point is more important, I guess, than the.
Well, also, you said you get more submissions than you can handle, so maybe it isn't really a problem that people can't find you.
Stop submitting, please.
Yeah.
Aaron, I'm curious. Was it supposed to be a takeoff on using the word fire in a movie theater?
I don't think so.
Because that's what comes to mind for me is that First Amendment and what classic example do they use is, well, you can say the word fire, but if you try to yell it out in a crowded movie theater, then it becomes a different. It could
just connote passion too, right? I mean, that's what I would think.
Yeah. No, but I'm just saying that's the one single word that really demonstrates First Amendment free speech issues. Oftentimes, that's the classic example they cite.
Right.
Absolutely, and unfortunately, we always have to deal with people raising that example when they're trying to justify censorship, which doesn't actually involve someone falsely yelling fire in a theater to cause a panic, which is the full quote from that original Supreme Court case, which, by the way, also didn't involve fire, but involved the government throwing socialists in jail during World War I because they, were opposing the war.
But they used the analogy, though, correct?
It was used as an analogy, yeah.
Okay.
But it's
I hate
frustrating
when
because
I hate when ignorant people throw that out there.
they throw it out in cases where the speech is clearly protected under the First Amendment, and you kind of have to explain that to them. But
well, it's like, but those of us who are well informed want to discuss, what qualifies as an exception and what doesn't, and they are acting like we won't accept any exception, and they have no idea what they're even talking about. That's been my experience in it. All right, let's talk about some of the other issues, like that I found on your X page, for example.
Sure.
This is another egregious violation, I think. And I'm no fan of Comey, but like fire, I like to think I'm a principled guy. Greg, I think you are too. This is not even close to an actual threat. What do you guys think?
I 100% agree. I wrote a whole piece about this case too a couple months ago. Not a true threat. A true threat is a serious expression of intent to inflict physical harm on another individual. And I don't think there's any serious argument here that Comey, by taking a picture of these seashells, it's not even clear that he arranged the seashells himself, but he took a picture, he posted it online. And this is a phrase or expression that is commonly used by people just to express opposition to President Trump. It was also used during Biden's term. There was Jack Posobiec is a pretty well-known conservative commentator. He posted 8646, and I don't think that was a true threat either. And he wasn't prosecuted for it and shouldn't have been. And I think this prosecution is just a joke.
Yeah,
but his Achilles heel on this may be the fact that he told investigators that he came across it but didn't arrange it. And I'm just curious if that is going to be disproven at some point.
It'll be thrown out probably.
I don't know. But I also think even if he did, I think it would be stupid for him to lie about that if that's the case. But I think even if he did arrange it, I still think that alone wouldn't be enough.
That doesn't make it a threat, right? Yeah.
1001 violation. Nope. Still a federal crime. You're lying to an FBI agent. He knows.
Oh yeah, no, I'm not denying that. I'm just saying that's why it would have been stupid for him to lie about it, because if he had just told the truth and admitted that he arranged the shells that way, if that's the case, I still think there wouldn't be any grounds to prosecute him for making a true threat.
Yeah.
Unless,
that's a good point. That's a good point, Greg. If they have evidence of that, but I don't know that they do. Also, he claims he didn't know that it has that meaning of killing him. And here's what I say to that. Even if he did intend it with that meaning, that doesn't mean that he's threatening to do it. If he wants Trump to be killed, you can say that's an ugly thought. But what is the theory of the threat even? Is the theory that Comey himself was going to go assassinate Trump? Or is the theory that he was going to hire a hitman? I mean, the people who claim it was a threat, I don't even think they've ever even explained it. Have you guys ever heard of the theory? Yeah.
Yeah, I think actually the exception that would be more applicable but still wouldn't ultimately apply would be the incitement exception of the First Amendment. Because like you say, if anything, he's kind of saying someone else should kill Trump, right? If that's but
incitement has to be imminent, right? Here I am pretending I'm the fire. I'm the fire. Yeah.
Exactly. You beat me to it. It has to be imminent. So someone would have to look at the post and immediately go out and attempt to assassinate the president. And it's just that's just a silly argument to make.
All right. By the way, I live in North Carolina, and that's where it happened. So I don't know exactly why I'm saying that, but all right. So we already
seashells, right? You didn't arrange those seashells, I hope.
I could go over to the beach and do an investigation, and so this is also now. You said earlier it's not that big a deal when the government isn't involved. Well, hold it. I guess the government is involved because the Kennedy Center is a government building. So Whitney Cummings spoke at, was this the Bill Maher? Yeah, the tribute to Bill Maher. Mm-hmm. And she made a joke that the Kennedy Center ordered Netflix to cut out. The joke was, I actually heard Trump may come tonight, but he couldn't make it, Cummings said during the taping. He got caught in sex traffic. All right, whether or not you think that's funny, doesn't seem like all that naughty. It seems like a very typical kind of a joke. Are you concerned that this government agency, if that's what you would call the Kennedy Center, told Netflix to cut it out?
Yeah, absolutely. Like you say, it is a government entity, So the First Amendment applies to the actions that they take. So this would be an example of what's often called jawboning, when the government leans on private actors to try to get them to censor speech on its behalf. Now, I think we just have this one article about it, so I don't know that's been officially confirmed that that's what happened, but it would be extremely concerning to me if any.
Well, I think it's a little different than jawboning, because according to Netflix, they weren't just leaning on them like the way the Biden administration was leaning on Facebook, but they actually had it in their contract that,
I see.
That the Kennedy Center had final approval of what was in the show.
Okay. But
there could be other legitimate things too, like,
Yeah.
cutting things for time and so forth. But
right. Yeah. The concern would just be if they were pressuring them to cut it because.
Well, that's probably the real reason. But I mean, and unfortunately, I think we've seen plenty of evidence of the FCC in particular going after various media companies and television shows and threatening them with punishments based on the content that they broadcast that is in some way critical of the administration or the president, which I would call that jawboning for sure, and I think it's really bad, and it's like you said, it's not something that is unique to this administration. The Biden administration jawbone social media companies to take down content related to COVID and election integrity. And Fire was we were hoping about that
the
too.
laptop.
The Hunter Biden laptop. But I feel like this FCC has really just been very aggressive and outspoken about it in a way that's pretty shocking.
But Aaron, let me ask you a question. I didn't
Sure.
get a chance to do any research on this, so I'm really winging it here, which I don't like to do. But the FCC, with regard to networks that decided they were not going to air a national presidential speech, it strikes me as a version of their own censorship, because it's not like. And the thing is, okay, full disclosure, I support a lot of the positions of the president, not necessarily his language or his demeanor, but the positions. But putting that aside, it struck me as inherently unfair that they decided not to carry that broadcast because they anticipated what his speech would be about. And it's not like he's on TV giving a national address to the country, 4 times a week, where they say, okay, this is getting to be a little too much now. It's usually a traditional acceptance to broadcast a presidential address, and some networks carried it, others opted not to. But aren't we getting into an area where now they're deciding, they're going to censor what content they approve of versus what they don't approve of?
There are definitely arguments that people can make, and I think are totally reasonable, about whether that network should broadcast this type of content. And
I want to hear it and evaluate it, and I can believe it or not believe it, but I don't want somebody else to tell me this is not going to be credible, so we're not going to show it.
Yeah, I mean, look, it's totally understandable. I think it's reasonable to argue that news networks have, if their goal is to air content that is newsworthy, then generally a presidential address to the nation is going to qualify, and it shouldn't matter whether or not they agree or disagree with the president's views on any particular political issue. That being said, I did see some reporting that during the Biden administration there were certain addresses that they also didn't air. So I don't know that it's
other presidents too. So I don't.
Yeah, I don't think it's. Totally
I don't think it's the most egregious offense, based on the same thing having been done to other presidents, and also there's no problem finding the address. There's plenty of choices. These networks all have offshoots with the different cable outlets and so forth, and they all showed it in one place or another, if not on their main broadcast channel.
Okay.
Yeah, I think at the end of the day, the issue that really concerns me the most is the government trying to dictate to any network, any television channel, what content that they must air. I feel like that was a bit of an escalation by the FCC chairman, where up to that point he had been threatening broadcasters with investigations and license revocations over supposedly distorting the news or airing fake news and things like that, or even like a late night comedian making a joke.
Yep.
But here he's suggesting that if they don't air something that he thinks that they should broadcast, that they could get in trouble for that. And that to me, compelled speech is an especially kind of creepy authoritarian type of censorship, where you're forcing anyone, whether it's a person, an individual, a media company, or whoever, to speak to platforms or platform speech against their will.
Right. This tweet that I showed earlier, I only talked about the second part before, but the first part, he's saying to me, why don't I interview at least one kid from Columbia University or some other Ivy League school that got silenced? So let me ask you, Aaron, are there any particular college students who would be a good poster child for a free speech violation that deserves to be amplified? Because I'll accept responsibility if I fail to shine a light on it.
Oh man, if you go to FIRE's website, you could find a bunch of campus cases, and you can find speakers, students, faculty on the left and the right who have been victims of censorship. But in terms of recent ones, one that comes to mind is at Florida International University. There were some students. These were students on the left who oppose ICE and the federal immigration enforcement, and they attended a event where the university president was like one of these. She was having a fireside chat type of event, and the students just engaged in a silent protest. They had shirts that said ICE. I think it said ICE off FIU, like off the campus. And they quietly left after a few minutes. But the university actually is disciplining them and forcing them to write an apology, even though they in no way engaged in any type of conduct that disrupted the event. Now you can't go into an event and make so much noise, or pull the microphone or the fire alarm or whatever, do something like that would actually prevent the event from proceeding. But just a silent protest that doesn't actually, prevent anyone from observing or hearing what the people on stage are saying, that's well within the First Amendment's protection. So maybe you want to get in touch with those students. But, just to give an example from the other side, something we often see on campuses, because a lot of campuses are, right, I'm sure I don't have to tell you guys, like fairly left-leaning among the student body and faculty. And so we often get cases where right-leaning student groups like Turning Point USA will have trouble gaining official recognition as a student group, because often the administrations will delegate those decisions to recognize a group to the student government. And when the student government is populated by people all on one side of the political spectrum who don't have a particularly strong belief in free speech, they'll often deny recognition to these groups. And we always oppose that, because we say, if you're a public university or a private university that promises free speech, you have to uphold that by deciding whether to recognize a student group without respect to their political viewpoints. And you can delegate that decision to the student government, but then the student government also has to abide by those same principles.
I did actually interview a student a while ago, I think it was a couple of years ago, that was represented by FIRE, who was kicked out of her art school because she had published some erotic art somewhere. It didn't even have anything to do with the school. And it wasn't even obscene. It was just very mild. What's that Japanese kind of erotica? What's it called? Anime? Or
anime?
like that? Anime, yeah, that's what it was. So I did do that. But, I don't think these Columbia students as a group are the most sympathetic, quote unquote, victims, because a lot of them were acting unlawfully, if that's what this guy has in mind. They were occupying property unlawfully. They didn't have any right to take over the campus. They were They took over a room and barricaded themselves in. They chained themselves to fences, so on and so forth. A lot of protesters nowadays and people who support them seem to think there's a First Amendment to protest in any way, shape, or form, blocking traffic and so forth and so on. Is that something that Fire has focused on to make that distinction clear?
Yes. In fact, that's something that we've repeatedly done over the years and had to do quite often in the wake of October 7th, when you had these encampments on campus and the type of activity that you're talking about. But yeah, we do try to educate people about what the First Amendment does and doesn't protect in various contexts, including when it comes to protest. And that's right. You have the right to hold a protest on campus. You have a right to gather with people of like mind, and you can chant things like "from the river to the sea," even though some people find that deeply offensive, or they think that it's a call for violence or genocide. That's all protected speech. But you're right. Where it crosses the line is when you start doing things like occupying buildings, vandalizing property, setting up an encampment without getting the school's permission. There might be time, place, and manner regulations that say, you can't set up tents overnight, at least without getting permission from the school first. You can't kind of commandeer a public area of campus for yourself and not allow other students to walk through. We saw that happen at certain schools like UCLA. And you certainly can't block traffic without getting a permit from the city. If you want to have a big demonstration that uses the streets, you can do that, but you have to obtain a permit first so that the city can prepare for it and make sure that everything's safe and that there are barricades up in place so that it can proceed safely in an orderly manner.
Our pal Stefan in the Bronx asks, has Jeff forgotten that he was a youngster too, and the drive of young people is to change the world? No, I remember that I was rebellious and ignorant of the law when I was younger, but now I'm no longer ignorant. Do you think that my recollections of childhood should my recollections of childhood affect my analysis of the law? Stefan, is that what you're suggesting?
And look, some people sorry, I was just going to add real quick that some people, civil disobedience is a thing, right? And some people make the calculation that they're going to do something like occupy a building and suffer the consequences because they think that it's more important that they get their message out, and they think it's worth the sacrificing of facing whatever disciplinary consequences they're going to make. And you can make a moral argument that that's something that is worth doing if the cause is worthy enough. But it doesn't get you out of the legal consequences that you do have to face if you break the law.
I'm glad you mentioned that, because I do agree with that. With something like, in particular, chaining themselves to a fence, because that doesn't really create much of a problem for anybody. So therefore, it's morally okay to do that. I would not say that it's morally okay to block traffic, though, because you're creating danger for people who have nothing to do with your issue, by the way. That's part of it. For the last 20 years, it seems, protesters seem to have forgotten that it matters who is the culprit. They target anybody. That has nothing to do with the issue.
And traditionally, civil disobedience, this doesn't have to be the case, but traditionally it's often been employed where the protest itself is breaking the law that they think is unjust. So a textbook example of that is like back in the 1950s during segregation, when you had sit-ins at lunch counters or other segregated spaces. They were doing that to protest the law itself that was enforcing segregation. But the protesters who are blocking traffic, they're not protesting traffic laws, right? They're protesting something like climate change that doesn't have anything to do with the law that they're actually breaking.
Are you familiar with, I think her name was Elise Slotkin, when she questioned the 3 college presidents about whether or not there's a rule against calling for genocide? You guys
I think you're thinking of Elise
Slotkin. I think that's right, isn't it?
Is it Slot? I feel like isn't Slotkin a different congresswoman?
That doesn't sound like the right name. Audience, help us out.
Elise Stefanik. It just came to me.
Oh, okay.
Right, the New York.
And she questioned, I think, the Harvard president and the University of Pennsylvania and one other school, I think.
And MIT, I want to say.
Right. But that drove me crazy because everybody had the impression she won the day. not only at the moment, but also the way everybody reacted to it. But I thought that the presidents gave exactly the right answer. Maybe they could have worded it better or had a better attitude, but it was the right answer. There is no, I mean, factually speaking, no, there is no rule against calling for genocide. Number one, it's not the president's fault that the rule doesn't exist. It's just the correct answer. And then number two, Stefanik didn't even give a specific example. So it was exactly right to say, well, it depends on the circumstances. And she was huffing and puffing and all, you know, how dare you, that how dare you attitude. You know what I'm saying? Do you guys agree with that?
Yeah, no, I agree.
How dare you?
She definitely won a political victory that day. And the college presidents were correct. I think that they could have given better answers. You know, it helps not to just say it depends, or it depends on the context, or it's protected. It would have helped for them to
get more aggressive. Yeah.
Or also like explain why these protections are important, right? And to explain why these principles are important and how they protect people, ultimately protect people across the political spectrum from infringements on their right to speak, not just people who are calling for genocide. And you brought up a good point, Jeff, too, which is that, what do you mean by calls for genocide? Because the way that gets applied in practice is often, like I mentioned earlier, students chanting things like "from the river to the sea," where there's a dispute over whether they really are calling for genocide, right? If you ask them, they'll tell you that, no, we're just calling for Palestinian freedom and self-determination. You know, and you can believe them or not, but I don't think it's like crystal clear always what people mean when they chant slogans like that. And some people might mean it in different ways. So that would be the problem.
And who's to say that it's that context? Stefanik gave no context. So call for genocide. In what situation? Am I talking to my roommate in a dormitory? Am I speaking into a microphone in front of 100 people? Am I following somebody around, harassing them? Did I say it only once? I mean, who heard it? Who did he say it to? It's like no quote, no context of who it said to. And she won the day.
And by the way, you know, it's the term genocide actually gets thrown around more than people might think. Like I've seen it used, for example, where people who are like considered anti-trans activists will be accused, like their rhetoric will be accused of advocating for genocide of trans people, but they'll just be arguing for things, right? Like that trans people shouldn't be able to participate in women's sports. Or you know, or use women's bathrooms and things like that. You know, or another example is like people who argue. There's arguments sometimes that people who support abortion support genocide of babies. Right now, whether you agree with that characterization or not, it should be something like you should be allowed to argue against abortion, right? Whether or not people think you're arguing for quote unquote genocide. So that's actually not, you know, when she says calls for genocide, I'm worried about how that would actually be enforced in practice against a whole range of political speech.
Right. Well, it's still a distant second place to the word racism or racist. That has about 900 different meanings, and it's starting to lose its value. Are you looking at your clock? Do we need to?
I was actually just looking at my my dog that I think does want to go out. But
oh, okay. Well, we can wrap it up. We've been talking for a while. Let me just ask you quickly one more thing about this ordinance here. We talked about, you know, the vagueness of Section 3, but also what caught my attention was the thing at the top. Whoever does any of the following in public or private place. Has it ever been enforced that, you know, you said something rude in your house to somebody and then the police show up and arrest you?
That's a good question.
Other than like maybe a domestic dispute if there was violence or something like that, but actually like being offended by what was spoken.
I guess I'm wondering how they define private there, because say you're on private property, but it's like a public event, but it's in a privately owned building. And
like
I guess
a banquet hall, you mean, kind of a thing?
Yeah.
Okay.
There's also lightning, which is why we're getting.
All right. All right. We have to defer to your dog.
This is disorderly conduct, by the way.
in a private residence.
Yeah.
Right. All right. We've been just so people know, they can find you or your organization at thefire.org, and they can follow you on X at Aaron Terr, your name 1. Aaron Terr 1.
Yeah, can you believe there was already an Aaron Terr? I had to add the 1 to.
I've never heard the last name till tonight, so yeah, that's wild.
Well, you are terrific. Bad joke. All right, take care. We love you, Aaron. Thank you so much for all your time. Tell your dog we apologize.
Well, all right, thanks, guys.
All right,
take care.
Have a good one.
All right, a better piece of comedy maybe than my terrific joke would be when Mike Tyson was on the Norm Macdonald show a few years back, and he was trying to get Norm to say the N-word. So why don't we close with that? It has a little thematic consistency here.
I want to hear you say that word.
I don't want to say it because then it'll be on tape forever. I say it in my private life many times.
Say it, hunky. Say it, hunky. Say nigga, hunky. Fucking say it, hunky.
Listen, am I wrong or am I imagining that?
Nah, say nigga, hunky. Say it, hunky. Come on, cracker.
Well, I didn't say it because I didn't want to get in trouble, but I might have said it if Mike Tyson was threatening to beat me up. But Norm wouldn't say it. Good for him.
And Norm's no longer here to defend himself, so.
No. And we can't blame Mike Tyson for that.
No.
All right. Well, thanks, Greg. Fun show. And we got some laughs and also covered a really important issue. I'm glad Aaron agreed with me that he said it right from the beginning. He hopes it goes to the Supreme Court.
Yeah.
It's that important.
Yeah.
All right. Tomorrow night, join us at 7 p.m. Eastern time for Ask the Inspector with Scott Ritter. And then Thursday night, also at 7 p.m. Eastern time, join us for The Whiners when our guest will be geopolitical analyst Cyrus Jansen. And we'll be back next Tuesday at 7 Eastern. Nighty night, everybody.
Good night.